A lot of people always say, I've been defamed, can I sue? And the answer is you can, but you have to prove a tangible economic damage to you, to your reputation.
Today in this video, let's talk about defamation.
He's since filed a suit for defamation again.
Probably sue for defamation.
Another suit against Cohen for defamation.
To bring a libel suit, a slander suit. Now this is a suit for defamation, for damage to her reputation.
Our world has transformed radically. We are far more connected than ever before, with a global network at our fingertip. With a few taps on the keyboard, we can write anything about anyone without permission. It could be a tweet, it could be a negative comment, it could be a blog, it could be even a video about someone, and that could be without their consent, and that could be defamatory, and that's what we call it as defamation. So how do we navigate through it? Here there are two kinds of remedies that one can approach to. First is civil and second is criminal. In civil remedy, one can proceed and seek compensation, while in criminal proceeding, one's intention is to punish that person through the mode of imprisonment or fine. So one of the common questions that I receive is that, can I invoke both the remedies, civil plus criminal? And the answer is yes, you can invoke both the remedies. You can prosecute a person under civil and criminal remedies. So now let's talk about the jurisdiction. Say someone has made some defamatory comment against you who is sitting in Mumbai and you are sitting in Delhi. So which court will have the jurisdiction? Will it be Mumbai court? Will it be Delhi court? And here's the catch. If someone has made a defamatory comment against you, say a tweet has been made against you, and someone who is in Delhi could read that tweet, could have access to that tweet, then you are well within your right to invoke the jurisdiction of Delhi court and track that person to the court of Delhi. Now let's delve deeper into the criminal aspect. The offense of defamation has been defined under section 499 of the IPC. And according to the IPC, the maximum punishment that could be given for the offense of defamation is of 2 years, or fine, or both. But remember this, that it's a non-cognizable crime and a bailable offense. It means that not only it's very difficult to file an FIR in such situation, but also the accused is well within its right to seek bail. So he will be out while the proceeding will go on. But the question comes, what if the defamatory content is right out there on the internet while the trial is going on for months and years? And in such situation, civil remedy comes in. I often recommend my client that we should be first sending a very stern legal notice. A lawyer should be sending a very stern legal notice to the accused stating that the content be removed ASAP, or else that person will be dragged to the court. It will reflect to the accused that the victim here is very serious about it and he is going to invoke his rights and drag that person to the court if the content is not removed. In many situations, the other side give an apology and remove the content, and then thereafter there is usually no need to proceed with the litigation. But suppose that legal notice doesn't work, or say your reputation has been tarnished so bad that not only you want that content to be removed ASAP, but also you want compensation for the loss of your reputation. In that case, we file a civil suit for injunction and damages. And when you file this suit, you also file an accompanying application, an application for interim injunction. Basically, you want to persuade the court that you cannot wait till the matter is over, because say when the matter is over in a month or year and court comes to the realization, yes, indeed there was this defamatory comment which was made, but for that whole period that defamatory comment was right there on the portal or in the publication, and there has been continuous tarnishing of your reputation. So if you are able to establish this fact before the court will direct the portal or the accused to remove that defamatory content ASAP till the time the matter is concluded before the court. Now that the defamatory content is off the internet, you can relax while the suit proceeds. Say defendant contests this matter. Defendant will have to produce their side of defense, what we call it as written statement. Then court will consider both sides of evidence, then court will hear both sides of arguments, and then court will pass the judgment. Say if court comes to realization that there indeed was defamation, then court will confirm the interim injunction which was granted in your favor. So say if defendant does not appear before the learned court, the court will then pass an ex parte order, and it would usually be in your favor. And if court directs the defendant to remove the content, or say directs the portal to remove the content, and the content is still there and it's not being removed, then you can prosecute either of them under Contempt of Court Act. where there are provision for imprisonment and fine. And also, thank you so much for 5,000 plus subscribers. It means world to me, and I have never imagined that I could get these many subscribers. And also, I have this other good news to share, is that I have recently written this book, Franchise Laws in India, with my co-author Brahmakrit Rao Gadela. This book has received foreword by former Chief Justice of India, Shri N.V. Ramanna. Book is on Amazon, so you would want to read this book. This book give a very detailed explanation on how to establish franchise in India and what kind of agreement you should have.